Hence, in my considered view, the action of demonetization initiated by the central government by issuance of the improved notification dated 8th November 2016 was an exercise of power contrary to law and therefore unlawful. Consequently, the 2016 Ordinance and 2017 Act are also unlawful. But having regard to the fact that demonetization process was given effect to from 8th November 2016 onwards, the status quo ante cannot be restored at this point of time. What relief may be awarded in the present case? In view of the above conclusion, the question of molding the relief shall now be considered. According to the petitioners, around 86% of the volume of currency notes of the total currency in circulation in the Indian economy was demonetized. They also stated that the people of India were exposed to undue hardship owing to the lack of financial resources and had to undergo not only a severe financial crunch, but were also exposed to other socio-economic and psychological hardships. The problems associated with the measure of demonetization would make one wonder whether the Central Board of the Bank had visualized the consequences that would follow, whether the Central Board of the Bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law, having regard to the interpretation given above. It has also been brought on record that around 98% of the value of the demonetized currency have been exchanged for banknotes, which continues to be legal tender. Also, a new series of banknotes of Rs 2000 was released by the bank. This would suggest that the measure itself may not have proved to be as effective as it was hoped to be. However, this court does not base its decision on the legality of legislation, weigh the effectiveness of such action in achieving the stated objectives. Therefore, it is clarified that any relief molded in the present case is divorce considerations of such success of the measure. Learned Attorney General, appearing on behalf of the Union of India, contended that the issues raised in these petitions have become infructuous and wholly academic, as the action of demonetization has been acted upon, and therefore the present cases are only of academic significance. It is necessary to examine the nature of relief that could be molded by the court in this matter. Thereafter, citing Bommai, Golaknath, Orissa Cement, etc., I have given my conclusions with regard to section 26(2) and the interpretation that it has to be through a legislative process. And in that summary, subpara 9, I have said, the opinion of the Central Board of the Bank ought to be an independent and frank opinion after a meaningful discussion by the Central Board, which ought to be given its due weightage, having regard to the ramifications it may have on the Indian economy and the citizens of India, although it may not be binding on the central government. On receipt of a negative opinion from the Central Board of the Bank, the central government, which has initiated the demonetization process, may still intend to go ahead with the said process after weighing the pros and cons only by means of an ordinance and or parliamentary legislation, but not by issuance of the Gazette notification. In other words, the central government in such circumstances cannot resort to exercise of power under subsection 2 of section 26 of the Act by issuing a notification in the Gazette of India as if it were exercising executive powers. Even if the Central Board of the Bank concurs with the proposal of the central government, the central government would have to undertake a legislative process and not carry out the measure simply by issuing a Gazette notification. In view of the aforesaid conclusions, I am of the considered view that the impure notification dated 8th November 2016, issued under subsection 2 of section 26 of the Act, is unlawful. In the circumstances, the action of demonetization of all currency notes of Rs 500 and Rs 1000 is vitiated. Further, the subsequent ordinance of 2016 and Act of 2017 incorporating the terms of the impure notification are also unlawful. However, Having regard to the fact that the impugned notification dated 8th November 2016 and the Act have been acted upon, the declaration of law made herein would apply prospectively and would not affect any action taken by the central government or the bank pursuant to the issuance of the notification dated 8th November 2016. This direction is being issued having regard to Article 142 of the Constitution of India. Hence, no relief is being granted to the individual matters. In view of the above conclusions, I do not think it is necessary to answer the other questions raised in the reference order. Before parting, I wish to observe that demonetization was an initiative of the central government targeted to address disparate evils plaguing the nation's economy, including practices of hoarding black money, counterfeiting, which in turn enable even greater evils, including terror funding, drug trafficking, emergence of a parallel economy, money laundering, including hawala transactions. It is beyond the pale of doubt that such a measure, which was aimed at eliminating these depraved practices, was well intentioned. The measure is reflective of concern for the economic health and security of the country and demonstrates foresight. At no point of time has any suggestion been made that the measure was motivated by anything but the best intentions and noble objects for the betterment of the nation. The measure has been regarded as unlawful only on a purely legalistic analysis of the relevant provisions of the Act and not on the objects of demonetization. In view of the answers given by me to question number 1 of the reference order, I do not deem it necessary to answer all other questions of the reference order or even the questions reframed by His Lordship B.R. Gavaije during the course of the judgment, except to the extent discussed above. In the result, the writ petitions, special leave petitions, and transfer petitions are disposed of in the aforesaid terms. All pending applications accordingly stand disposed.